Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Let's further here on the polls. Join me now is lawyer for Chairman Wontumi, Samuel Atta. We appreciate your time here on the polls. You're asking the court to postpone judgment simply because you have only recently taken over the case. Why do you believe this is even necessary at this time, knowing fully well that the AG says that they're done and dusted with this case?
Well, then what is the point of filing addresses if they are done? And if you go to the law, I mean, the accused person is entitled to address the court. The law says so clearly. And right now, there is a very serious climax of the case that we shouldn't play down at all. The man is bereft of counsel. The whole state, the Republic of Ghana, is represented by the Attorney General. Why is the state represented by the Attorney General? Because of the power of counsel. The Attorney General is going to urge upon the court that Wontumi should be imprisoned or convicted. And now the individual is having no counsel. But the Attorney General is going to address the court and file processes to divert. Why should we not have fair trial that I should also study the proceedings critically and then aid Wontumi and submit that the case is not proven beyond reasonable doubt. For that matter, it should be acquitted and discharged. And why are we in an ambulance mood relative to the liberty of the individual and fair trial as enshrined in the Constitution? I can't come to terms with that.
But he has always had legal representation, and Akyea has been his counsel. And the Attorney General argues that your application is already coming in at a time where he feels it's only to delay the proceedings. And so I'm wondering how you respond to those accusations.
Why should anybody say that we want to delay the proceedings? Now, do you expect a carpenter to remove the tooth of a patient, or you want a dentist to do it? What is more critical here is that the law says that he's entitled to address the court. And how do we address the court? Unless I internalize, the proceedings that have gone ahead of me. I don't have a clue about the case. So if the Attorney General is insisting that, let's close the door to the accused person in terms of addressing, the court, and then I will have the opportunity to address the court, that's an unfair prejudice to the accused person. And I can't understand why the Attorney General will not give a little space to the accused person so that we address the court. And whenever the judge is ready, after having listened to arguments from us, the judge will come out with this decision. That is what justice is all about. I thought we have a Ministry of Justice. Is that not so? Or we have a Ministry of Prosecution. So if you are in an indecent haste to have the case done at the expense of the accused person, then what justice are you ministering to Ghanaians? I believe the Attorney General should see his role as a very fair player in the justice delivery system, rather than saying that, we are ready, we believe we are going to have convictions, we believe, what kind of, advocacy is that? So I will make my points very clear that by operation of law, if you want to have fair trial, there's an opportunity that the man should not be bereft of a lawyer. They should have the benefit of counsel. I'll look at the proceedings, and then I'll write out my submission for the consideration of the judge. After all, the outcome of a case is more serious for the accused person than the Attorney General. If you look at the balance of hardships, a man hasn't gotten the opportunity to, address the court. Probably by some error, he goes to jail. How do you compensate for it? And how is the state going to suffer if we are given a couple of days or even weeks to come out with a credible address to aid justice? How is the state going to suffer? I can't understand that.
But at what stage did you assume responsibility for Chairman Wontumi's defense? Because we've always known that Akyea has been representing him. He tried to withdraw his legal counsel. The court did not permit that. And so why exactly Is there a need for a change of legal representation at this point in the proceedings?
Well, subsequently, I don't know the technical issues that visited the application for withdrawal of counsel, but I got to know later that, he filed it. The process that is out of the case. So, madam, the critical matter is that can you do a serious legal work as an individual who has no legal training? When the Constitution talks about the right to counsel, what does that mean? That means in critical matters of this nature, a lawyer should represent you. And how can the lawyer do any competent job? Unless he comes to terms with the proceedings. And is it too much for a lawyer to study, the proceedings, marry it with law, and write out a very competent written submission to aid justice, and then the judge will consider? And then you believe that it's only the Attorney General who should write a one-sided argument for the consideration of the judge? I think it will be to the disadvantage of the accused person. And that will not be in sync with fair trial as enshrined in the Constitution.
Now, I'm wondering, if the court dismisses your application and proceeds to judgment, what will be your next line of option?
Well, we'll advise ourselves, why should anybody say that we want to delay the proceedings? Now, do you expect a carpenter to remove the tooth of a patient, or you want a dentist to do it? What is more critical here is that the law says that he's entitled to address the court. And how do we address the court? Unless I internalize, the proceedings that have gone ahead of me. I don't have a clue about the case. So if the Attorney General is insisting that, let's close the door to the accused person in terms of addressing, the court, and then I will have the opportunity to address the court, that's an unfair prejudice to the accused person. And I can't understand why the Attorney General will not give a little space to the accused person so that we address the court. And whenever the judge is ready, after having listened to arguments from us, the judge will come out with this decision. That is what justice is all about. I thought we have a Ministry of Justice. Is that not so? Or we have a Ministry of Prosecution. So if you are in an indecent haste to have the case done at the expense of the accused person, then what justice are you ministering to Ghanaians? I believe the Attorney General should see his role as a very fair player in the justice delivery system, rather than saying that, we are ready, we believe we are going to have convictions, we believe, what kind of, advocacy is that? So I will make my points very clear that by operation of law, if you want to have fair trial, there's an opportunity that the man should not be bereft of a lawyer. They should have the benefit of counsel. I'll look at the proceedings, and then I'll write out my submission for the consideration of the judge. After all, the outcome of a case is more serious for the accused person than the Attorney General. If you look at the balance of hardships, a man hasn't gotten the opportunity to, address the court. Probably by some error, he goes to jail. How do you compensate for it? And how is the state going to suffer if we are given a couple of days or even weeks to come out with a credible address to aid justice? How is the state going to suffer? I can't understand that. We wouldn't want to sort of, place our weapons in the public space, But we will advise us. I believe the judge will exercise the powers of justice and give us the opportunity to address the court. I believe the judge should have a sense of fair trial as enshrined in Article 19 of the Constitution, and give us the opportunity to address the court.
Okay, stay with me. Let me bring in a private legal practitioner at this point, Lawyer Martin Kpebu. We appreciate your time here on the Pulse. We're just hearing from lead counsel from Chairman Wontumi tell us that there are a lot of legal bottlenecks, and there are concerns that if their application for at least an extension of time is not granted by the court, they will be ensuring that there is no fair trial moving forward. What legal grounds really are they that lawyers can rely on to justify such a request?
So these things happen. That's the one lawyer withdrawing and another one coming in. So usually the strongest reason is that the new lawyer is new. The new lawyer is new. So usually the court grants some time, okay? And because the new lawyer doesn't know the whole case. And customarily, or maybe the word is not custom, let's say usually, at least, you would find 1 month, a judge granting the new lawyer 1 month to study. But the cases vary. So in a case where the judge has a hunch that, look, the bringing on a new lawyer is just to delay the case, you would not easily find 1 month. You may find less, 2 weeks, 3 weeks. Yeah, so look, let me tell you plain truth. Usually, these things, as I said, no two cases are the same, right? The circumstances of each case would determine. That's why I said that when a lot of factors point to an attempt, an orchestration to delay the trial, the judge will not readily give 1 month. He may give less. But as for giving a bit of time, it's to be expected that once you have a new lawyer in front of the judge, right, there would be a bit of time given for the new lawyer to be able to study. And this one too, so you see, another factor that would be, the court would be looking at is that, as far as I'm aware, so when I say 1 month, you see that in this particular case, the attempt to change a new lawyer and the announcement of a new lawyer didn't happen today. You see that it's been some weeks. It's been at least 2 weeks. So the judge is looking at how much time to give the new lawyer. Would also look at how much, because it's public knowledge, because I remember clearly that a little over 2 weeks ago, we had this same conversation, yes, on Joy News. It was top story. And at that time, it was already clear who was coming. That Honorable Atta was taking over. And I remember it's been over 2 weeks. So that would also be, and it's public knowledge. So this is, I mean, we do this in newspapers, etc. So Honorable Atta will be asked, when did he take over? It will come from when it came out public, and there are stories on it when he took over. So to be very clear, it's not as if the 1 month would then start counting from the day the judge deals with the case. You see, but as for getting a bit of time, it's likely that he would get. But the specifics, I'm saying that it varies from case to case. And in this case, the news had already been in the news portals for at least 2 weeks now that Honorable Atta was taking over. And so the time will start counting from when the news was made public.
But in this case, where the AG argues the case is far advanced in terms of the trial and that what is left is just the declaration of judgment, do you think they even have a case in court?
Oh, it's still the same answer. So, you see, when I say the same answer, it means that this is the basis of it. You can't force a person to work. So Akyea cannot be forced to continue working if he doesn't want to work, and for so many reasons, right? So he pulled out, and as I said, his pulling out was more than 2 weeks ago, right? And then we heard Honorable Atta had come in, right? Yeah, so for me, as far as I'm concerned, once the new lawyer has come in, right, he will get some time. So it's not, when you say the case is very much advanced, let's be very clear. There's no way, let me just answer. There's no way a court will say that because the case is advanced, a new lawyer cannot come in. No. Even on the day they have to give judgment, a new lawyer can come in. Yes. So because you can't force the lawyer who wants to withdraw to continue working. You see, we've abolished slavery more than 300 years ago, right? Yeah. So you can't force somebody to work if he says he cannot work. It's personal service. It's rendering personal service. He's using his skills etc. So once Akyea says he can't continue, he has to be let go, and then a new one take over. And when the new one takes over, he needs a bit of time.
I see. Let me bring back Samuel Atta. I want to find out from you, beyond the procedural issues before the court, are you even confident that the evidence presented so far during the trial supports your client's innocence?
Well, Madam, I don't want to pretend that I have clairvoyance, but I'm telling you that as Counsel Pebu is saying, it takes a professional lawyer to internalize the processes so he will know what to do. So I've not read the processes. I just got the full gamut of the record yesterday. So I'm going to spend some time with it. But for me to be afforded the opportunity to peruse the record and advise my client and or file a written submission is in aid of fair trial, because I've urged upon everybody that, look, even the state or the republic is having a lawyer. How much more an individual? So what is the understanding of the balance of justice, where the state is being represented by a whole attorney general, but the individual is now bereft of lawyer when the case has climaxed? And Martin will agree with me that this is the most important point, where you summarize the proceedings, marry it with law, and make submissions that the case has not been proven beyond reasonable doubt, which could sway, it doesn't always happen, but it could sway the judge that this man deserves an acquittal. How can anybody say that this is not too important to be considered by the judge? So I'm very surprised that even the Attorney General filed an affidavit, in opposition, and say that we are trying to delay the trial. But then, if you don't give us the opportunity, and then we don't shed light on the case from our perspective, and the man suffers miscarriage of justice, how do you compensate for it? Just a couple of weeks could be fine for us to put it across. People go to the Supreme Court and they ask for extension of time. So justice is ministered. And it will be seen by the whole world that, look, even the judge said, I've given you a little time, put across your case and let me consider it. That is fair trial and justice. But to shut the door on his face when he has no lawyer, I don't believe that will be justice.
But the Attorney General maintains that the trial has already run its course, and that all parties really have had the opportunity and ample time to present their case. And so what exceptional circumstances really will justify a reopening of the process at this stage?
Yes, the exceptional circumstance is the law at 30. I don't want to argue the law here now, which says that the accused person is entitled to address the court. It's a whole statute. So therefore, if the lawyer is no longer with him, how can a lay person address the court and write written submission? I'm very glad that, my colleague has been a very prominent person in a justice delivery system. Everybody is quoting him, Martin Pebu. It's all because of justice. How can you expect a lay person to address the court? And therefore, I'll be pretending that I'm an Einstein in the law, that within, 2 weeks, I'll be able to read the entire record and write a credible written submission. I shouldn't be pretending that I know too much. I should take my time and look at it. So I'm not saying that the judge should not deliver the judgment. I'm saying that by reason of the circumstances and me coming in lately and at the climax of the case, it should give me the opportunity to play this role, all in the interest of fair trial, as enshrined in Article 19.
Because how much time really do you need, realistically speaking?
Well, I don't have to say everything here. I'll urge it upon the court. And the judge also understands how long it takes. For a lawyer to, put together a credible written. So when she should ask me, I'll ask for some good time, a reasonable time, so that everybody will see that I'm not trying to delay the process, but I want to, with the greatest of respect, defend my client in accordance with law and shed light on the case from my perspective.
And what would be reasonable and good time to you? 3 months? 2?
Oh no, it won't be 3 months. At all, it won't be 3 months. But I think we will talk about reasonable time when I'm before the court.
I'm interested in the reasonable time. At least it can help us plan ahead. Even as journalists, we want to know, is a month okay for you?
Well, if you push me, 6 weeks will be fine. And the realm called Ghana will not cave in if a citizen of this country is given 6 weeks to put together a credible written submissions. It will not affect the inflation in the realm. It will be consistent with fair trial and criminal justice. That an individual with no professional training, cannot address the court, and the judge said, I'll give you some allowance because you were a Johnny just come. Familiarize yourself with the proceedings and write out what you think is the position of the accused person. We are not asking for too much.
And we know that this case has attracted a lot of public interest, especially because of the allegations surrounding illegal mining. How would you ensure that your legal strategy really remains focused on your client's constitutional rights rather than the political attention surrounding the case?
Well, I believe it's because of the political tensions that sometimes it's making the Attorney General run faster than is required. Because sometimes they want to play to the gallery and satisfy constituents. But when it comes to justice delivery, madam, it's not how bad Galamsey is or how terrible it is, which will be the underlying factors to deal with an accused person, but the law and the evidence. A man should not be sentenced on the basis of public sentiments. Martin knows what I'm talking about, as to how they feel about it. But as to how the law as put together by the Attorney General will ground a case which has been proven beyond reasonable doubt. It is not Galamsey that is going to rewrite our Evidence Act for us that prove beyond reasonable doubt when it relates to a criminal matter. No. The law is independent of the feelings and the sentiments of the general public. If not, I'm afraid we will be tried in the in the court of public opinion, and people will be guilty before they are sentenced. And that is terrible indeed for the nation. That will not be upholding the rule of law. But then we are whipping the sentiments of, some constituencies and political people who believe that, you've been here for too long and if you not secure warrant, imprisonment, relative to opponents. That is not law at all.
Stay with me. Let me bring back Martin Pebu. The AG's argument is simple. This case has run its course. What is left now is judgment. If the court dismisses the application based on the arguments being made by the AG, what are the likely next available legal steps that the defense team can apply?
Then it means they would attempt to arrest the judgment on the day it is to be delivered. So let's say on July 3. Now, do we see that July 3, it appears would be a public holiday? So that means that ordinarily it may not come off. Yes, you see, the courts have held in Pebu number 4, there's Attorney General number 4, that the court can sit on public holidays, etc. Right? Yes, so if the court wants, it can sit. But a lot of the time, if it's not a bail matter, very, very urgent, the court may say, under the rules, actually, the court will sit on the next working day, which will be Monday, July 5th. Now, so on the day, whether July 3 or it will go to July 5th, there is what lawyers call motion to arrest the judge. So the day the judge is going to give a judgment, the lawyer can file a motion. Let me use ordinary words, an application to the court to stop that, not to give the judgment because of some reason. Now, to put it simply, even though the court can throw out that last-minute application, what happens is that last-minute application is usually filed last minute, from its name last minute. So you will find that at the time they will be before the court, the Attorney General will not have a copy, the court will not have a copy. But the lawyer, accused and his lawyer, so Wontumi and his lawyer, can show their copy to the judge. And once it's shown that it has been filed, then it means they have to postpone the case a bit to consider the reasons for which Wontumi wants to stop the court from delivering judgment. And even on the return day, that's the day it is finally dealt with, even if it's thrown out, then now there's an opportunity to go on appeal. So actually, it's easier gymnastics. There are a lot to be deployed. But it's heartwarming to hear Atta saying that it doesn't need more than 6 weeks. Now, we can say this, to move the law forward, right, to get all of us, we are a nation. I like the statement made that Ghana is not caving in the next 2-3 weeks. We'll be here for centuries. We will even die and go, and Ghana will be here. So based on that, if he goes in with a request for 6 weeks, I'm sure they can negotiate and then come somewhere in between, middle of the road. Because when I say middle of the road, the court will go on vacation on 31st July. I've not checked. Is it a working day? If it's a working day, then that day the court will work. But if it's 31st falls on Saturday, then it means that the last day will be 30th. If you can have somebody check which day 31st
I think 31st July is a Friday.
Very good. So that's the last day the court will work, and then the court has to go on a break. So till, let's call it roughly 10th of October. There's a way to calculate it. If I calculate it, it will waste time and maybe some people will not follow us. So now, this is what I'm saying. So if within August, September, some special courts will work. When I say special, meaning a few courts will work to deal with only urgent matters. So let's say, what's your name again? Is it Jema Ofori? Or what's your name?
Say that again.
Hello? I said, what's your name? Let me give you your name for an example.
Faustina, cancel.
Faustina. Okay, Faustina, Safo, good. Now, Faustina, assuming somebody wants to take your child away, your husband wants to run away with your child to the U.S., and it's 1st August or 10th August. That one, we cannot wait till October. So there is a way your lawyer can run to court, and then they will seek to stop him. So what I'm saying is that in the months of August and September, up to about the 10th of October, thereabout, it's only very urgent matters, or somebody is building on your land, etc., but not to give judgment like in the Wontumi case. So that's what I'm saying, that so we have up to 31st July. So when Akyea goes in and they negotiate, anytime before or on the 31st of July, it's possible. It's possible because he says he needs 6 weeks. Maybe he goes and is able to persuade the judge. The judge may say, I'll give you 3 weeks more. It may come in the middle or 3rd week of July. Or worst case scenario, the 4th week of July. Or there's also the other option that if he wants to give an undertaking that he will agree to the judge to apply to the Chief Justice for extension. So I told you that the August, September, up to the first few days of October, we don't do such judgment in criminal cases. Others we don't do. If he wants to agree that he insists on the 6 weeks, which will take him into August, then in that case, if you agree that they will apply to the Chief Justice that they should do the judgment in August, everybody will be there. We are a nation, good faith. And the judge can come and deliver in August. But otherwise, August, September, and the first few weeks of October, it's holidays. We don't do this type of business. That's giving judgment in the criminal case. And let me be clear, when I say holidays, that's High Court, Court of Appeal, Supreme Court. And even those ones, they do urgent cases. And I'm saying this judgment is not the type that is called urgent. Unless Akyea agrees that he will come to court in August, and then he will agree and write to the Chief Justice, then the judge will apply, and then it can be done.
I see. Stay with me, Martin. Let me bring in Samuel Atta to find out your next line of action. You are pleading for 6 weeks. If you don't get 6 weeks, what will be your next line of action?
Madam, I beg to remain silent on my next line of action because I don't want to, with the greatest of respect, practice the law in advance. I'm hoping, and I'm praying also, that the judge should have exercised the discretion in our favor that any person before the criminal court who has a right to counsel, and the right to counsel straddles the entire trial till you get the address, and the man has no lawyer at the climax of the case, giving us a little accommodation will not shortchange the state. I believe the judge should see through this and give us the space to do some good work, all in the ultimate interest of justice. Because at the end of the day, people will also be saying that, why is the judge depriving a man of the opportunity to present his address as enshrined by law. What do you say? Do you want people to say that, oh, the judge was jaundiced against Wontumi, and when he was disadvantaged because he didn't have a lawyer, he ravished the whole situation and gave a judgment? So I'm afraid it is not that simple, but I'm very excited this hour that as always, a marching sense of the law is sound. And I'm very, very glad, because sometimes people believe that, oh, we are just playing with situation, we want to delay justice, but that would never be a delay of justice. As a matter of fact, it's going to advance justice. A man's address was put together, and the judge looked at it and came to one conclusion or the other. That is what we are praying for.
Well, some people are of the opinion that the NPP would be electing its chairman soon, and we know that Chairman Wontumi, he's vying for that position. So this is simply delay tactics, just to buy him enough time to contest and, if possible, win that seat. How do you respond to those concerns?
It will be a lottery of a projection to think that Wontumi will be the next chairman. We don't know. And even if you look at all these matters that he's grappling with, we don't know the outcome. But madam, in as much as people might want to project politics, which they love to do, one thing I will say, this country is a nation where we should uphold the rule of law. A man has been arraigned before a competent jurisdiction, and I am of the view that every accused person, whether he has political proclivities or not, is not the matter. What is the matter is the law. And the law is saying that he can address the judge. Now he hasn't gotten a lawyer. Let's put MPP aside. We are praying in aid his right to counsel at this climactic stage of this case. And if somebody believes that, oh, let's read politics into it so that he becomes the chairman, that is his own permutation that I won't take from him. But as far as I'm concerned, we are not urging anything MPP on the judge. It's only the law. And we are going to do so forcefully.
Your final words.
Well, I pray to God that because we have the rule of law, as even enshrined in Article 19 of the Constitution, talking about fair trial, the Attorney General is representing the Republic of Ghana in the case. The ordinary citizen of Ghana hasn't gotten a lawyer to aid him write a written submission. I trust God that even for even balance and equity in the law, the judge should give us a space so that we put our case across. That is our humble prayer, and we're going to urge upon the judge to do so.
Thank you so much. Samuel Akyea is lawyer for Chairman Wontumi. I want to wrap up with Martin Pebu. Your final words.
Okay, that's well. So it's all right. What I'll say is that as Akyea said, he will not dabble in the politics. Just to remind citizens, you see, sometimes when people of his party, I'm not going to the politics of it, but it's important. You see, people of his party started ridiculing this administration that Ora is dead, Ora is dead, Ora is dead. You see, so now today he needs more time to study brief. But because there's political pressure from citizens that Ora is dead, you see, it has put Wontumi's case in a bind. So when politicians set out to, cause disaffection for a government in power, sometimes it's better that they think ahead, because we think which political case are they ever saying? Remember those days, various governments come in 1.5 years and they are done. Some of the cases, the people who were convicted, Ibrahim Adam and Co., Kwame Tetra, the NDC people those days, 2 years, 3 years. But this one is what? Just about a year, and they are done. You see, so the caution is to the people who seek to make political capital out of everything. You are ridiculing the ruling government. Ora is dead. Ora is dead. Now, Ora is about done with one of the cases involving Ashanti Regional man. And the lawyer needs more time to study the brief. You see, so this is a warning to politicians to stop giving citizens, stop causing disaffection needlessly. You see, in our crave for power, we say things, and then those things come back to bite us. And that's what Wontumi is facing now. Otherwise, ordinarily, this request Atta is making, it's not any extraordinary request. It's not difficult, easily, but for the political disaffection the party is caused, this thing could have gone into October. Like I told you, because we are going on vacation, it could have been adjourned into October. But some people have caused the party, the government, a lot of pressure. Ora is dead. Ora is dead. And so the prosecutor, Attorney General, won't take it lightly to agree that Ora is dead. That's how come this is causing all this tension. That if they will not agree for Akyea to spend more time studying the brief. But like I said, I believe at the end of the day, they will find middle ground so that something can be done, so that he can get more time, but before 31st July. Or, like I said, they always want to improve the law. So if he wants to improve the law, he should give an undertaking to the court and write to the Chief Justice that he will do business in August. And so with that, I'm sure as a whole nation, if they put it public opinion, everybody will argue that, the court is to be on break, but the lawyer says he will work. Citizens are referees in this case. Everybody will say, if the lawyer says he will come to work, then please, they should let the judge also work. Then, when they are done, the judge can take his vacation from October to November thereabout. Because as I mentioned, in the vacation period, some judges will take to deal with emergency cases. So this one too can be qualified. In this case, we can agree that they will do business in August. Then they can finish in August.
Into it because, like all contracts, I think Wontumi has the right to change his counsel, or the counsel himself also has the right to remove himself from the case. So I don't think we should read too much into it, except to say that from what I'm saying, maybe it may be strategic. I don't know, but I'm thinking that maybe it may be strategic. The strategy, or the purpose of that strategy, in my opinion, being to try as much as possible to prevent the judgment, the supposed judgment on the 3rd of July from being read. Because, I think they give them a date to more or less file their written submissions. Now, that is very critical. Because it is in that submission where you make your arguments, you try to persuade the court. You must understand that in criminal cases, generally, the burden always is on the accused to prove, to persuade the judge as to the guilt of the accused. Now, that does not also take some burden from the accused here, especially since the submission of no case didn't work. So personally, for me, I'm not reading too much into it, except to say that I think that I see a strategy here, and the strategy is to try as much as possible to push the judgments.
The 3rd of July that the court is.
Yeah, because Atta would need time, really, because he was not a lawyer on the case.
Mm-hmm.
Was he going to?
I see he's starting that argument that it would be unfair. So he's hoping that
these arguments we all make. I think is what you will say. We all make those kind of arguments when you enter the case. But I'm saying that I see strategy here, because really, for me, the reason was called my learned friend on the Akyea gave for leaving the case for me is not tenable, except that he has a right to remove himself from the case. The strategy for me is to find a legitimate excuse why the judgment on the July 3rd cannot be read, and because there's a new counsel in, and yesterday you heard him say he will need time to go through the docket to prepare what's called, or to file his written submission. That's normal. We all do that, and we should give them that.
Even when the courts rejected the idea for the lead counsel to abandon the
court didn't reject it. You should read argument. So what the court said was that Akyea didn't need that process as a reason to leave the case, as in he could leave the case. So it wasn't that the court rejected. Really, you don't need the court's permission to enter into a contract or not to enter into a contract. So if you read what the court said, the court simply said that Akyea did not need that application. Yes, and that application was incompetent, in fact, to use the words of the court, and that he had the right to, by simply filing, by what's called the accused simply filing, what's called change of solicitor to change him. So it wasn't the court didn't refuse Akyea could be.
It was a confusion many didn't understand because it's sounded to many Ghanaians that, well, but if the court didn't accept, which I'm glad that you point the confusion in there, you can't force a council to be.
Exactly.
Yeah, so it was just a process.
It was a process. So the court simply was saying that you don't need this process to take yourself out. Yes, so, and I think they have done that. So right now, Atta is council, and I cannot argue against that because, like I said, it's something that we all do to be honest, and it will be unfair on not on even the council, but on Wontumi, because you see, per the principles of natural justice, all opportunities has to be afforded him to defend himself, and so I think that it says right for Akyea to seek a bit of time to go through all the processes and then file the first right and then file the case. I think they should be the court can accord him that. But for me, I'm saying that
should the court accord him that?
I'll be a hypocrite if I say the court should accord him that, because like I said, I use that. It's not that we all do. I can sit on TV and say that.
The lawyer laughing.
Yeah, it's something that.
Okay.
It's something that. So I'll be very.
It's a trick, eh?
It's not a trick. I'll be very hypocritical.
It's a module you use. One of the ways.
No, it's not one of the ways. But you see, when you enter a case fresh, you'll be very irresponsible.
But you don't just enter. You enter and you're giving everything, how it started, where you are, and where you are.
But in that huge docket, you think that you need time to go through, especially when the written submission, hasn't been filed. If the written submission had been filed, then probably we could make that. But while the written submission hasn't been filed, the new council would need time to go through, the
criminal cases you represent. Changing lawyer for
the summary boy.
The summary boy, not the one that they are seeking.
Not exam. Not the plea bargain. Is the summary boy. Illegal mining.
The date for judgment.
Yes, because what happens is that they'll give you, we are giving you, let's say 6 weeks or 2 weeks or 3 weeks to file your written submission. So file your written submission by.
We should be due 24th for that particular case. 24th of this month.
And 3rd July for judgment. So what they did was they changed the council before the written submission was even filed. I'm saying that it would be unfair on the part of it would be unfair on Wontumi himself if the new council is not given enough time to go through, because he wasn't in the case, to go through the processes. That's what I'm saying. I see strategy here. But I'll be a hypocrite.
Your head. If you were in Wontumi,
I'll be a hypocrite if I sit on TV.
The child is sick and he would die. Is it legal? Like put him in the packet of the poop.
Oh, nobody's.
That one I agree with you.
Until we put him in that packet.
Let us put him. I think the whole Ghana knows. But the point is, it will be very highly hypocritical to sit on TV and say that Akyea should not be given that opportunity, because for all intents and purposes, he wasn't in the matter, and to be very unfair on to himself. So they should grant them that opportunity.
Okay.
But what is saying, I'm sure the judge by now understands the case very well, and he's going to dispense with justice.
Okay.
You should trust that the judge is going to dispense with justice.
Well, Honorable, I see where you're taking your argument from already. You started from the Pope's pocket.
Well, I think that, again, like my brother said, it will be unfair. First of all, let me say good morning to the people of Trifuetimokwa. I mean, I am representing in Parliament. It would be very unfair for anybody to say that Wontumi have no right to change solicitors if that's what he feels he want to do, or if the solicitor himself representing him, my own brother Akyea, could be feel that where I've reached, I think that I've exhausted my capacity to deal with the issues, or there are many reasons why as a judge, a lawyer would want to recuse himself from continuing representing a client. One could be that, okay, the fees that I charge the client to pay me, he's not paying. Therefore, I don't think my services will be available to my client again. That's fine. It could also be that they do not agree on principles of strategies as to going into the case here and there. So let me recuse myself because what I'm trying to do, my client is not interested and is not understanding. So that could also be a reason for a counsel to recuse himself. So there are so many reasons.
Akyea Kubi is very clear.
Again, there's another reason that Akyea Kubi is citing is that there are certain things that the court is doing that he is not able to take.
Yeah.
I wonder how Atta is going to take what the court is doing anyway. That Akyea couldn't take. But that's for them to do. Nobody can seize or challenge and deny any individual as the kind of person to represent them, especially when it comes to dealing with matters of criminalities and all that. But you see, when you go into the mind of the situation, you begin to reason through certain things. I mean, all the accused, witnesses have been called and they've been interrogated. The case have closed. They are supposed to file a written submission. Then judgment will be delivered. Now, Akyea realizes that he couldn't continue again. Is it that he's not able to write the written submissions? He's incompetent, incapacitated in writing the written submissions?
No, why are you going outside of the reasons he has submitted?
Well, the reasons he has submitted, again, I have my right to also reason through the reasons he submitted. He cannot also, if you like, chain me to the reasons that he submitted. Again, so the question is that what is it that may necessitate? When the case started, when they were doing the case right from day one till the case closes, he didn't see reason to recuse himself. Now it is time to write written submissions and the judgment is delivered. Now he sees it. So the point is that somebody may reason, if you like, with me, that it's an attempt to delay the case and trying to see whether, the Exim Bank, for example, issue, now pre-bargain and all that. So it's trying to massage things and all that. But like I said, what will happen will happen.
Okay.
Judgment will be given, but I trust the integrity of the court. And I believe that the court will give judgment according to the merit of the case.
That's fine.
Will not be on anybody's. Today, I see some social media running around. People are trying to do some social begging of people and all that. That is not.
I'm sorry, about what?
Yeah, about people thinking. I saw some video where Wontumi on radio, I'm not bigger than begging the former president for insulting him, the current president for insulting him and all that. But and I feel so bad because His Excellency John Dramani Mahama, I tell you what, he's not even interested in the case. He's not following the case. So people thinking that when we go begging President Mahama, we weigh the merit or where the case should go, the judgment and all that, that totally should be taken out of the equation because His Excellency Mahama is not even thinking about what is in court. He's not even interested. This is purely about Wontumi and his own issues and the court of competence coordinates and so forth and so on. So everybody, individuals will feel that going to His Excellency Mahama will have anything to do with criminality, determination of criminality in our courts, and a court of competent coordinates should begin to reason differently. So that, Tokonu told us the law is the law. So, so let's allow the law to continue to be the law. Going around this little gimmick here and there. Yeah.
Every other thing Akyea is asking for is also in law. Anyway.
There's nothing really that is going to change. What is going to happen will happen.
Okay.
The judgment will be delivered. If it is today, it will. Tomorrow, it will. Tomorrow. Whatever it is will happen.
Okay.
And so for me, I think that let's continue to pray.
For who?
And
pray for who?
Let's continue to pray for Ghana. Let's continue to pray that justice will continue to be delivered according to the merit of the case, but not whom you know and who knows you.
Okay. I think it's a good place to land on that prayer note. Let me go to Uncle.
I hope you are not being sarcastic.
You'd rather go to the lawyer.
You say you are dealing with the lawyers. Me, I'm not there. What do you refer to yourselves?
Learned.
I'm not a learned person, but
I started with
what kind of book they read before they call themselves
learned? I'm a learned person.
Yes. I started with the lawyer because I wanted him to situate the matter that has come from there. You see to him, right? Yes. Okay. Well, Kwesi.
I'm a father.
Is this a module? Is this a tool you would use as a lawyer to buy time?
I, from my little years or my few years in legal practice, I've come to realize that legal practice is not just about the law. It's about strategy as well. Mm-hmm. A good lawyer, I think, is a lawyer who knows the time to use the law and the time to employ strategy.
Did you hear that?
You don't always need a law. Sometimes you need strategy. And you know, strategy actually plays out even during your Crocs examination, like Council mentioned, even how you write your written submission. Because there is no formal template on how you do these things. And so you need strategy. And so strategy is part of law. But let me start by saying that the right to legal representation is a constitutional right. Every accused person has the legal right to legal representation. And that I do not think that the courts in Ghana can compel any accused person to be represented by a certain lawyer or a particular lawyer. The choice of legal counsel is at the discretion of the accused person. It's at the will and desire of the accused person. It is the accused person who has the right to appoint any solicitor he or she feels he can work with. And so I think that Wontumi, to start with, has that right. Secondly, as we speak now, Wontumi is still innocent because the Constitution prescribes that every accused person is presumed innocent until proven guilty by a court of competent jurisdiction. To the best of my knowledge, Wontumi has not been convicted or has not been proven guilty by any court yet. And so the matter has not been concluded yet, even though trial has ended, because trial starts from somewhere and it ends somewhere. You start with CMC, the prosecution will now do its case, and there will be the accused person has the right to file an application for submission of no case. If the court deems that the accused person has questions to answer, the court will order the accused person to open his defense. The accused person will also now put out his defense, and then at the end of the day, the trial will come to an end, and then counsels will write their written submission, which is not mandatory anyway, and then the court will give its final judgment. And so, as we speak, like counsel rightly mentioned, the burden still rests on the prosecution. The Constitution requires that, or our criminal justice system requires that the Constitution prove its case beyond reasonable doubt. What the accused has to do is to raise a shadow of doubt in the case of the prosecution, and the accused person is good to go. Now, we are being informed that the lawyer for Chairman Wontumi, and let me add this, that just as the accused person has the right to appoint his lawyer, a lawyer of his choice, the lawyer also has the right to also accept a client of his choice. The lawyer can decide not to accept you. For instance, if Honorable Wondi brings me a civil matter, I can decide to accept. Because the civil matter, the legal fees will be good. But if he brings me a criminal matter, I can decide not to accept. So it is a two-way, you know.
Are you suggesting that Wontumi was not paying his lawyer?
Actually, I've not said that. But that is also one of the grounds under the Legal Professions Act for a lawyer to decide not to represent a client. But that is not the reason Akyea Kubi, the learned Akyea Kubi, has given. And so let's respect his reason.
Well, I'm only suggesting that to you anyway.
And so the lawyer can decide to choose his client. Now, in the spirit of fair trial, if the client feels that at a point in time he cannot work with the lawyer, or the lawyer feels that at a point in time, for certain stated reasons, he wants to change his lawyer, in the spirit of fair trial, it is only appropriate that you allow the accused person to go with the lawyer of his choice. And in the circumstance, we are all aware that a date for judgment has been set. Now, the question as to whether or not Counsel Akyea would plead with the court for an extension of time to enable him study the record of proceedings of the court, to enable him put together a very solid written submission. Let me also state that extension of right is not as of right. It's at the discretion of the court. The court can decide to reject that. I don't know if you come by way of motion or by way of oral application. The court can decide not to agree with Counsel Akyea and refuse his request for extension of time, the court can still be firm on the date set for judgment. Like I've already indicated, legally, written submissions are not mandatory. Some lawyers even decide not to write written submissions. It's not mandatory, you understand? And so I think that let's allow the judicial process to work.
Yeah.
Counsel Atta is a consummate lawyer. He's been at the bar for over 33 years. I wasn't born when he was called to the bar. He knows the law far better than I do. He knows what to do. He owns one of the biggest law firms in this country, Akyea & Co. His wife is also a consummate lawyer. His first son is a consummate lawyer. And so it's a family of legal brains. He knows what to do. I will not sit here and advise him on what to do. I will not even try to do that. I will not sit here to advise counsel and the Akyea could be on what to do. I will not even try to do that. But all that is happening is permissible within the legal and criminal justice framework. And so let's not read political and mischievous reasons into what is happening.
While you draw attention to the fact that the court can decide to want to, change the date or maintain the date, they already said, how common is it for a court to actually change the date they set for?
It happens all the time.
Is it quite common?
It happens all the time. It happens all the time. Even in civil matters, it happens all the time. Like Counsel mentioned, change of solicitor or...
Not the solicitor.
No, I'm saying it goes hand in hand.
Okay.
So once you appoint a new solicitor, he will need time to study the record of proceedings because before he can make any meaningful argument. Because lawyers have a lot on their plate. You don't call a lawyer today and the next day he's in court arguing as if he's been with you since day one. No.
Right.
And so it is only proper and in the spirit of fair trial that you allow the accused person's counsel, new counsel, the opportunity to study the record of proceedings. And I am even aware that the Leonard and the Akyea could be actually appealed the decision on the submission of no case.
Yeah.
And so all these things will come to bear. Counsel can even make the point that because there is an appeal pending before the Court of Appeal, which is higher than the High Court should arrest this judgment. Because if the High Court proceeds to give its judgment on the substantive matter and the application for and the appeal for the submission of no case succeeds, that will amount to a mockery of justice. You understand? And so there are so many things that Counsel Atta can do. Like I'm saying, he's a consummate lawyer. He's been in this game for a very, very long time. He knows what to do. And I am only praying that in the spirit of fair trial, the courts also know what to do because the matter is still before the court. I would not want to go into the details of the court and whatever. But to land on what Honorable mentioned, that he is in a video of Chairman Wontumi pleading with President Mahama. I think that in all sincerity, today it is Chairman Wontumi, tomorrow it may be Honorable Wondi because he's a board member of SIC. So tomorrow it may be him. So in all sincerity, and he's a public officer as a board member as well, he receives taxpayers' money and all that. He receives fuel allowance and all those things from the board. So tomorrow it may be him. So I am speaking from the standpoint of Chairman Wontumi being a Ghanaian standing trial. In all sincerity, we are being told that he's being prosecuted under the ambit of oral. But the charges before the court has nothing to do with embezzlement of state funds. And so I have been wondering how Chairman Wontumi's Samraboy matter of his alleged assignment to a third party without going through the right legal process. I am wondering how that amounts to Operation Recover All Loot. What exactly is the state seeking to recover in this matter? What monies has Chairman Wontumi stolen from the state?
Are you suggesting that because commentaries suggest that Operation Recover All Loot, the Attorney General has all the powers to want to initiate different...
Under the policy framework for Operation Recover All Loot, we were told that people have embezzled close to $21 billion.
Yes. At the time was Chairman Wontumi's matter cited in that $21 billion.
No, that vehicle was to recover the $21 billion. They didn't tell us that Operation Recover All Loot was to go after people who have been alleged.
When the Attorney General
I am not saying Wontumi cannot be prosecuted. That's not what I'm saying. But I'm saying that regarding what Honorable mentioned, there is a perception. And all of us around this table will agree that there is a perception that what is happening to Wontumi is political witch hunt.
That's not true.
There's a perception. And we cannot discount and invalidate that perception. And so if the person himself has found reason and cause to sit on national radio to appeal to the president, then that fits into the larger perception that because some people believe that Chairman Wontumi in the heat of the campaign said something against the then opposition leader, and that now he has political power, so he wants to teach him a lesson. I think that all these, that's why I said perception. All these perceptions are things that, you know, at the end of the day, I mean, but
would you not be quite disingenuous towards the court to know that the court will sit on matters that have substance? If it's political witch hunt, the court will sit on anything else.
But a political matter.
If it is witch hunt, if it is witch hunt, and then the Attorney General can present cases that can be found are criminal.
A witch hunt can be a case that has substance. When the matter is described as a political witch hunt, it doesn't necessarily mean the matter is without substance. No.
But you agree that we've used this witch hunt over the period, suggesting it there.
And I'm saying
there's no case.
And I'm saying that
you can't take witchcraft matter to court by the way.
You say why is he
the accused person has, you know, he's had cause to believe that maybe the certain president, in some way or the other, is offended by certain things he said about him. And
I'm saying that if indeed the president feels disrespected, I mean, he has cause to go towards defamatory. But if the Attorney General goes into that matter, that fact, and gets facts and get issues that are quite criminal, he can just pursue it.
That's why I said that there is the perception.
That perception.
I have not seen the video. I have not seen the video of the respected Chairman Wontumi on radio, quote and unquote, begging President Mahama. I have not seen the video. But from what Honorable is saying, that he has seen the video. And I'm saying that if indeed the regional chairman has done something like that, then it fits into the larger perception.
But he is attempting to want to actually debunk that perception that if you think that the president is the one that is interested in you, and I'm saying that, but he is here saying that, I didn't want to go there, but since you've introduced it, my understanding of his submission is that if you think that because you had made certain comments about then candidate Mahama, which is why you are being witch hunted, I am giving assurances that the president is not even interested in this matter
at all.
The Attorney General is the one looking at facts and wants to pursue. How will
in all sincerity, Honorable Wondi cannot say as a matter of fact that the president is not interested in this.
He's interested in anything that's illegal mining. He's been very public about that. Yeah.
Honorable Wondi cannot say as a fact that the president is not interested or is not aware about the prosecution of.
Aware is different. I'm sure aware you understand the English language. Interested and aware.
And so, yes. Whether or not the president is even interested, that's not even my concern. The point I'm making is that there is a perception, and the person who is standing trial now feels so alarmed to the extent that he has to sit on national television to beg the president. Then I think that feeds into the larger perception. And so, LFA, I would not say more, because this is still a matter pending before the court.
Okay.
I will only pray for fair trial, because Councillor Akyea could be resigned as counsel for Chairman Wontumi on grounds that the judge has not been fair to him. And so,
do we not hear this all the time?
I will plead.
If it is not going on.
As a lawyer, have you not heard this all the time?
Why should anybody say that we want to delay the proceedings? Now, do you expect a carpenter to remove the tooth of a patient, or you want a dentist to do it? What is more critical here is that the law says that he's entitled to address the court. And how do we address the court? Unless I internalize, the proceedings that have gone ahead of me. I don't have a clue about the case. So if the Attorney General is insisting that, let's close the door to the accused person in terms of addressing, the court, and then I will have the opportunity to address the court. That's an unfair prejudice to the accused person. And I can't understand why the Attorney General will not give a little space to the accused person so that we address the court. And whenever the judge is ready, after having listened to arguments from us, the judge will come out with this decision. That is what justice is all about. I thought we have a Ministry of Justice. Is that not so? Or we have a Ministry of Prosecution. So if you are in an indecent haste to have the case done at the expense of the accused person, then what justice are you ministering to Ghanaians? I believe the Attorney General should see his role as a very fair player in the justice delivery system, rather than saying that, oh, we are ready, we believe we are going to have convictions, we believe, I mean, what kind of, advocacy is that? So I will make my points very clear that by operation of law, if you want to have fair trial, there's an opportunity that the man should not be bereft of a lawyer. They should have the benefit of counsel. I'll look at the proceedings and then I'll write out my submission for the consideration of the judge. After all, the outcome of a case is more serious for the accused person than the Attorney General. If you look at the balance of hardships, a man hasn't gotten the opportunity to, address the court. Probably by some error, he goes to jail. How do you compensate for it? And how is the state going to suffer if we are given a couple of days or even weeks?
MPP party constitution, a man who can say, oh, problem. It's your party member, as I said, Wontumi eko edi petition koma party no na the petition ma party na party no petra petition so me refer petition ma disciplinary committee no e to me so be investigating complaints no concerns that so-called misconduct na oma make full and faithful impartial inquiry. Omuya no ma report in writing and verbal.
Okay.
Omu report to omuhu ye I'm a party na I make a decision on it. The committee no anti petition omudia koma National Council and a party no relative to Kennedy or Hine Japan. Mati say MPs bi kura di petition so akọ but ye nim MPs kura ndie ye betwen na ye hu omo ayaka sem but minia na tiene say then na Kennedy kan ye enti ane MPP for twin Kennedy akọ disciplinary committee asama Kennedy kan ye na trouble ni wo o fire national anthem na or see God bless our own Ghana, yes, sir.
Yes.
So you will be bold, strong, bold enough to defend. And this is defending my Ghana. In this case, Kennedy was defending the country Ghana. And Bonibena Kennedy, aye. Onye Bonibia. Say ban defense, say who defend the Abayan Fufra. In MPP constitution, it is not wrong. Say Bibia Koso, now would defend this deal with a Koso Kanokre. The MPP constitution does not support lies. So we dethrone a Chenipa. There be any MPP constitution in Musa. And no call for Barry, Ninaye, Afari. Military hospital, na woku myself. Yes. And now, I think, say, MPP MPs, led by Dr. Akyea, Nana Free, as a more quafari, and a challenge bar, and a more pressure to advise so, advise intimate completely afari. Send a bear, a bit me a boa, na Yashaya, Sawo, Ashanti Maimo. And the Kennedy did the birthday. And as a trophy could be started, na Safari, I deal with what dream travel, and also. Me and Yanu NDC MPP. As I see a dream of mine Ghana. Now, me can do in Japan, there, my Defense and Interior Committee Chairman. MPP, they are buying 8 years. Afari Anyari Avon. FM. And to my MPP, first of all, and more NDC are buying. on Afari. Oba na obeye bi to aso a anka ntiti. Unua. Ene ye kase. Embi bi atima akire ne omo ye to aso ana in 8 years. Who didn't call this man committee say what did throw at Ghana for ana? Say the second part I'm also a threatening party now, or someone trying June, July 2027. Mubehu. So basic party head office namamu. Munim. Say obey ya doye is na okoye na doye na. You don't know. And the problem day. In any case, MBB should be the last party anchor about complaining about hospitals. Ni say Nanado Danko Akufo-Addo be president oni baomia. Na Afari hospital project na wo ho me boa.
Yes.
Na sewua wo ho. Ansa na omo launch agenda 111. Oni wa say omo amfa sa hospital menu we anka agenda 111 hu so SSC etimi wie hospital we prioritize our hospital project we say na be ye betimi aboa amaya nya yare se bia na yetimi aye amanfo ayahwe ewo Asante Mountain